probable cause is a standard of proof. So really there's sort of the spectrum of burdens of proof that are used in different phases of different kinds of court cases. So most people are familiar with the beyond a reasonable doubt. The way it's explained in law school is beyond a reasonable doubt means you're 99% sure. There is no other reasonable explanation other than, you committed the crime. I guess in theory, aliens could have come down or, who knows what, but there's no reasonable explanation other than you did it. That's beyond a reasonable doubt. That's the standard for a jury or a judge in a bench trial to convict a person of a criminal offense. The next one down is preponderance of the evidence, which is what they use in civil cases. So if someone files a lawsuit against you, you just have to convince the jury, more likely than not, you didn't do what they said, or in their case, more likely than not, you did. So if beyond a reasonable doubt means you're 99% sure, preponderance of the evidence means you're 51% sure. There's other explanations, but you feel pretty sure that the person either did or didn't do what they're being sued for. Below that is probable cause. And really, it's a very low standard. It's just enough to initiate a case. So, is there reason to believe he probably did this? That's probable cause. That's enough to get a warrant. It's not enough to convict, but it's enough to get the case started. And then below that, there's what's called reasonable, articulable suspicion. And that's the proof needed for an officer to stop you and on the street and see if you're up to something. But probable cause is just based on the circumstances and the evidence available. Is there evidence to believe something that you probably did something? That's probable cause, and that's enough to get an arrest warrant, and that's enough to run a case all the way up to trial.